otherwise the recording won't pick up.
Pick you up.
I'm good.
And Amy Kraus is going to come in, she's gonna watch the recording because she's not gonna make it into
I've been sitting all
virtual
day.
for the
She's just gonna watch the recording. Okay, gotcha. Okay. I'm gonna go ahead and call the meeting to order then. This is actually a regular meeting of the governing board, but we're starting off a little bit differently this afternoon at 5 p.m. for a study session, the subject of which will be mandatory reporting training, ably brought to us, I'm sure, by Lisa Ann Smith of Deaconcini McDonald Yetwin and Lacey, our law firm. We are live streaming this study session for anyone who's interested in watching this via YouTube. So I'm going to just go ahead and call this meeting to order. We'll go back to the normal opening when we're done with the study session, where we'll do the pledge and the welcome and all that kind of stuff. And I also just wanted to notify folks that I am sitting in for Amy Kraus, who's out of town. And she will be viewing the recording of this section of the meeting at another time. And I will also be running the main meeting for her while she attends remotely. So if anyone is wondering why I'm sitting in this chair, that is why. So we're going to go ahead and be open, and I'm going to just turn it straight over to Lisa Ann.
Thank you, and I understand that I can have a laptop. Perfect.
Yes, you may. Just as a little introduction, this is fulfilling the requirement for our board members to be trained in mandatory reporting, as that is a new requirement, and you are new mandatory reporters per state law. So this is going to fulfill your annual training requirement.
When this is an annual training requirement.
This is an annual training requirement.
Right?
Okay, on my screen it looks different, but I'm good. So I am going to do for you this evening the same presentation that I give to all of your new teachers every year. And so you'll see I have a bunch of examples in this. They are more pertinent to teachers than they are to you, but I mean, the law is the same, and you'll see what they see. So what we're talking about is Arizona Revised Statute 133620, and I like to point out that Title 13 in Arizona Revised Statutes is the criminal code. This statute, the education laws are all in Title 15, the education code. Title 13 is where all the crimes are listed and identified and all that kind of thing. And the reason why this statute is there is because failing to comply with the statute can lead to criminal liability. And what the statute requires is a report to law enforcement, or in some circumstances, the Department of Child Safety, when you have a reasonable belief that one or more of the following have been committed against a minor, in other words, a child under 18, or also an adult who has been declared to be incompetent or in need of a guardian. Child abuse, a non-accidental physical injury, neglect, or specified sex offenses. And in this presentation, I'm going to go through what all of those are as defined in the law. So you have to make a report, and you haven't had this training before because governing board members weren't listed until this year. There's a whole bunch of people who are required to make mandatory reports, including all employees of school districts, or all certified employees of school districts, but also medical care providers and social workers. There's other categories of people that are included in the law. I can actually list them all for you because I don't represent any of those kinds of people. But then this year they added school district governing board members. So you're required to report if you have a reasonable belief that a minor has been a victim of one of these crimes. And so the question, what's a reasonable belief? And this has been defined by the courts for us. It's a low standard. If there are any facts from which one could reasonably conclude that a child has been the victim of child abuse or physical injury, neglect, a reportable sex offense, then the person knowing those facts has a duty to report. And so facts from which you could reasonably conclude that this child has been a victim, that's enough. All educators are mandatory reporters. Teachers, classroom aides, paraprofessionals, site administrators, district administration, any district staff member, and, as I said, now governing board members. It is a misdemeanor to fail to report a non-accidental physical injury, child abuse, or neglect. It is a Class 6 felony to fail to report one of the reportable sex offenses, which I will go through and I'll tell you what those are.
Oh, sorry.
No worries. So the statute says that you can report to law enforcement or the Department of Child Safety, and it's like doubly negative explains that you have to make a report to law enforcement almost all the time. It's always a safe haven. 100% of the time you can make a report to law enforcement. If the allegation or the reasonable belief you form is that the minor's parent or guardian, a person who has custody or control of the child, is the person who is inflicting the non-accidental injury or the abuse or neglect, then you may call DCS instead. But it is always fine to call the police, and we recommend just always make any report to law enforcement, and that's what we train the teachers and staff on. And we also say, like, if sometimes people do call DCS because they prefer to, it doesn't seem as bad as calling law enforcement, basically. But we also train that if you call DCS, still also call law enforcement. Just better safe than sorry. You used to be able to, you have police officers in your schools, school resource officers in your schools, and because they're commissioned officers and they work for you under an IGA, they're actually, active police officers. You could make your reports to them, and that worked well for teachers at a school to go straight to their SRO and make a report. But the law now has been just recently changed this summer, and a report to an SRO or a SSO, school safety officer, school resource officer, is not adequate. A report has to be made to local law enforcement. So the thing is that what happens when a teacher makes a report, say to the Pima County Sheriff's Office here, if there is a sheriff who's, officer who's stationed at the school, they're gonna refer it to that person to do the investigation anyway. So when it's possible, and we'll talk about timing in a minute, but when it's possible, I think a good idea is to just for the teachers to go to the SRO, and then the two of them go to the telephone and make the report to the sheriff's department together, because that person is going to probably need to know about it. But the bottom line is that there has to be a call made, whether it's to 911 or the non-emergency number, depending on the nature of the call, to make the mandatory report. Then the duty's satisfied, but just reporting it to an SRO is not adequate.
It's really interesting. Do you know what's behind that, Jane?
Apparently it's different in Phoenix. Like in Tucson, all the schools they're not district employees, and they're on duty when they're working in the district. It's through an IGA. But I guess, because I asked that same question, I guess in some Phoenix districts or other places in the state, they're off-duty police officers who work as school safety officers. And so they're not technically reporting to law enforcement at the time if they go just to the SRO or the SSO. Okay, so you have an obligation to make a report immediately upon forming a reasonable belief that one of these offenses may have occurred. And immediately means immediately. So we tell teachers, you can get someone to come cover your classroom and then go make the report. So if a student came up to a teacher during class and made, some revelation that gave the teacher a reasonable belief, get someone to cover your class, go make the report. It's not at the end of the day, it's not a couple of hours later. And it's definitely not a couple of days later. And I mean, people have been prosecuted for failing to make reports quickly enough. So it's an obligation to do it right away. And the last point on that slide, and I'm gonna make this point a couple of different times, but it's clear, like every person who has a duty to make a mandatory report, it's a personal duty. It's your personal obligation. And so we train teachers, you can't wait to check it out with your colleagues, confirm with a few people or with your principal that it's okay to do. If there is a gray area where someone isn't sure if they have a reasonable belief, some facts have come to their mind and they're like, I don't know if this constitutes a reasonable belief or if this constitutes an injury, then inquiring with someone like a principal or a fellow board member or your superintendent or something. What do you think about this? That's okay. But if you've got enough where you already think that it is a mandatory report, then you don't need anyone else's advice. You just need to do what you need to do. So if you are a certificated person, so this doesn't apply to you, but and you make a mandatory report about a school employee, which includes actually any school staff, certificated, classified, or even a volunteer, then a report also needs to be made to the State Board of Education. So what I would say to you as board members, that in the event that you made a mandatory report about a district employee, you'd obviously would be in communication with the superintendent about the fact that you did that, and then she would make the report to the State Board of Education as well. Because they then want to, you know, be able to do their own investigation and say, like, does this person's certificate need to be looked at, potentially, you know, taken away, or do they need to be identified as a person who's not safe to be working in schools? So that doesn't apply, like, it's unprofessional conduct for a certificated person not to make that report. So you're not certificated people, I don't think, any of you, so you wouldn't have that same direct obligation, but obviously it's important to keeping all schools safe, so.
But by proxy, we would have that obligation.
Yes, once you
So-
tell this, exactly, yes. So, and so then the right thing gets done. So, and so I would say, like, this is the same, this is not your supervisor, obviously, but if you do have to make a mandatory report, then you should report it to the superintendent so that she's aware that it's happened, because, you know, it's just important if things come up, parents inquire, whatever she needs to know. Also, she can make the determination if a report needs to be made to the state board. But what we also tell, so we tell all staff this, you know, you need to tell your building administrator that you made a mandatory report, and they have a form they fill out so that there's a record of what was reported. But their principal, or, you know, the superintendent, no administrator is a gatekeeper. Like, you should never, there should never be someone saying, don't make a report unless and until you talk to me. It, like I said, I've said repeatedly, it's an individual obligation, and so you make the report and then you tell the person that needs to know. Okay, what if more than one staff person or more than one board member knows about reportable conduct? So under the law, every single person who forms a reasonable belief that child abuse or another reportable offense has occurred has an individual obligation to make a report, but obviously the police or the sheriff's department doesn't need to get 3 phone calls about the exact same situation. So, however, so only one person needs to make a report, but they need to make sure that the other reporters know that it happened, confirm to them that it happened. And so individually, if I find out, if I'm with Mindy and we both find out something and then she says, I'll make the report, then I'm gonna say, okay, great, send me an email when you're done and tell me who you talked to, when you called, you know, did you get a number? So I've got a record that my duty was fulfilled. I'm not just gonna rely on her saying, don't worry, I'll take care of it. I want confirmation in writing that it did actually happen.
Yep.
Yep.
Okay. So typically we have an understanding where we don't put multiple board members on an email, so that we're not in violation of open meeting laws.
Yes.
So how would we handle it in this situation? I know it's an extreme example, but
Right.
to use your example, if 3 of us became aware at an event, for example, and we all became aware of the same thing at the same time, how do we then handle that email closure that?
That's a
Or
good
the
question.
same report?
Right, so it is pretty unlikely, but
It is.
nevertheless, it could happen. I guess what I would recommend then is that the person who makes the report sends the email to Denise, and then she sends out an email blind copying all the members saying, this report was made and here's the information about it. Now you're not talking amongst one another, but you all have the important information that you would need.
Good question.
Yeah, and feel free, you can interrupt me anytime. It's better to just ask them as they come up than wait till the end. So, okay, so now we're gonna talk about what are the offenses that are reportable. So the first one is a non-accidental physical injury. So first, what's a physical injury? There's a list of things, like skin bruising. I mean, it's so pretty low level, right? A bruise, bleeding, a burn, a fracture, a head injury. Now they become more obvious. But not just a red mark or not just someone saying, ow, you know, doesn't necessarily cause a physical injury. There has to be some manifestation of the injury. Soft tissue swelling.
A child has a bruise, that isn't always going to rise to the occasion of having to make a mandatory report.
Correct, but this is just whether it's a physical injury.
Okay.
Because then we have to find out, is it a non-accidental physical injury? So a bruise is a physical injury, but if it's student or the child got a bruise accidentally, it's not reportable. Pressure sores, and then also failure to thrive, malnutrition, and things like that. So that's not very likely that that's going to come up in your role as board member. So actually, this is not a slide about this in here, but just to be clear, the obligation to make mandatory reports for all school employees and board members, it relates to information that you gain in your role as a board member. Anyone can make a mandatory report. And I'll get to that later. There's a safe haven that you cannot be prosecuted for making a mandatory report as long as you do it in good faith, even if you report that you think someone is abusing their child or has hurt another person and an investigation establishes that that didn't happen. If you've reported in good faith, you are immune from civil and criminal prosecution. So you always can make a mandatory report, and if you've got a concern about something, obviously that's a good idea. But the obligation to do it is when that information comes to you in your role as a governing board member or in your role as a teacher, administrator, or school employee. Okay, so that's a physical injury, but what are accidental injuries? So sometimes it's hard to tell. Obviously, if you observe someone hitting another person, then you can conclude it was non-accidental. But when you're seeing the signs of an injury on a child and you ask them, how did you get that bruise? Then you're going to be making a judgment call, probably based on what they tell you about whether or not it was non-accidental. So one of the things of how we teach the staff is children readily talk about accidental injuries. And so how'd you get that bruise? I fell off my bike, or I was hiking and I tumbled down a hill. You're like, well, that seems consistent and reasonable. They tell you about it. No reason to suspect that it's anything but an accidental injury. But if a child hesitates or gives an explanation that seems inconsistent with the injury that you're observing, those are signs, that would raise a suspicion that what they're saying may not be the truth and it may be something different that they're hiding. Within the law, there is kind of an exception to the non-accidental physical injury. It's kind of an exception because it is basically defining these as accidental, but we refer to them as schoolyard scuffles, and it says in the law a mandatory report is not required if all of the following are met. The minor who sustained the injury is of elementary school age, kindergarten through 8th grade. The physical injury occurs accidentally in the course of typical playground activity. The injury occurs at the school that the minor attends, and the parent or guardian is informed of the injury, and the school maintains a written record of the incident. Now, it seems like you don't need this exception because it says occurs accidentally, and you only have to report non-accidental injuries, but they've carved out this very specific exception, and this is how I interpret it. If you are, say, one student is pushing another student on a swing set, and they're being kind of, they're being rough, they're laughing, they're joking, but they're pushing hard, and the student flies off the swing and, hits the ground and hurts themselves. I use this example because my own son, when he was a minor, he wasn't at school, but at a friend's house, it was just all in fun, but he got pushed off the slide. He's 23 years old. He still has scars on his back from where he hit the rocky ground. So obviously he sustained a physical injury, but I would call that an accidental injury because the student didn't come up, his friend didn't come up and push him off to be mean. That would be non-accidental. He was pushing him on a swing in normal, like in this case backyard, but could be playground activity, and an injury occurred. So that is what I think fits into this exception for schoolyard scuffles. Okay, so that's a non-accidental physical injury. Also, a risk of injury or negligent supervision is also reportable, and this would occur when an individual who has the care or custody of a child places the child in a situation where they're at substantial risk of being physically injured. For example, an intoxicated parent comes to pick their child up from school in their car, that is to say. The child has access to weapons or dangerous drugs in their home. Physical violence occurs at home in front of the child. The child is left in the care of a known abusive person. And in some circumstances, the lack of adequate supervision. What adequate means, I'll talk about a little bit more. So those are also reportable offenses because you don't have to wait till the child is harmed. If you've got a reasonable belief, you've got facts that give you a reasonable belief that the child's in serious risk of being harmed or neglected, then that is reportable.
Lisa Ann, what if
Yes.
what if an intoxicated parent came to pick up a child at school, not in a car?
I guess you'd have to make a judgment call about it, because if you know they're walking next door, that's one thing. If you know they're walking across, a
Traffic.
busy street, then I would say that is too dangerous.
In the context for board members, like, if you were at an FFO meeting and a parent had their child there and he or she was intoxicated, that would be an example for a board member.
Yeah.
You were in your role as a board member at an FFO meeting and you witnessed something like that.
Or like you see them walk off, but if they were walking, you see them walk, it's dark, the board meeting's just over, you see them leave on foot, and they're crossing, Skyline or whatever, and they're standing in the median strip, and you smell, that to me would be, yeah. Were you gonna ask a question? No?
That's fine.
Okay. Parental discipline, corporal punishment is not illegal in the state of Arizona. So a student saying that they've been spanked by their parent is not a mandatory report, as long as it doesn't cause a physical injury. So if a child reports that their dad's gonna spank them because they, lied or whatever, that wouldn't be a mandatory report. But if a child reported that their parent had hit them with a closed fist or with a belt, a hanger, a wooden spoon, a stick, something that could inflict or does inflict actual injury, then that is reportable.
And to clarify, going back to physical injury, as it's in quotes there, a bruise qualifies as a physical injury?
Yeah. So if a student, was slapped on the face and their face was red for 10 minutes and then not red anymore, that's not a physical injury. If a student is hit by another person, including their parent, hard enough to leave a bruise, or grabbed, squeezed, shaken, that's reportable. Yeah.
Unless the bruise is the result of being spanked.
No. If the spanking causes a physical injury, it's a mandatory report.
Oh.
If a spanking doesn't leave a mark,
Okay,
then it's not a mandatory report.
gotcha.
It's like really the,
More permanent mark. because
exactly,
it's
like
you
pain
said.
is different than an injury, right?
Okay.
Yeah. Okay, the statute also references emotional abuse, which is defined as behavior that's been diagnosed by a medical doctor or psychologist. That the impact has been. And the practical reality is that a school employee or governing board member is very rarely, if ever, gonna have enough information to conclude that someone's being emotionally abused. So we don't go into it further. I think if you were seeing something that extreme and you formed a concern that that's what was happening, obviously you should make a mandatory report about it. Okay, neglect is the inability or unwillingness of a parent, guardian, custodian of a child to provide the child with the supervision, food, clothing, shelter, or medical care that they need if there is a substantial risk of harm to the child's health or welfare. So, a kid who comes to school without a winter coat, that's not neglect unless, it's all of a sudden dropped to 30 degrees below and they're in shorts and flip-flops, right? So it's like, this is something that it has to be neglect that provides a substantial risk of harm to the child's health or welfare. And again, like I think I said this in the beginning, and after I go through all the definitions, then I've got a bunch of examples of some of these things.
And going back to that, when we talk with our staff about it, it's not your standard of what you would
Yeah.
do with your children.
Right.
What's legal.
Yeah. Okay, and then the last category of things are the reportable sex offenses. And in general, I was going to say if there were any students here. So if your children are watching online, I'm going to use some explicit terms right here. But the reportable sex offenses involve the touching of the vagina, penis, anus, or female breast specifically. And it includes penetration, fondling, touching, oral contact. It doesn't matter if it's over or under clothing. It doesn't matter if it's minor to minor, and except for one exception, which I'll get to in a minute, adult to minor, sexual abuse, sexual conduct with a minor, sexual assault, molestation, incest, all of those are specifically listed as reportable offenses. The reason why we use the specific terms about the touching is because we do get calls, is this a mandatory report? And sometimes it's inappropriate behavior, squeezing or slapping another person on the butt, cheeks, it might be sexual harassment, it might be other things, but it's not a reportable sex offense. And same thing with touching the male breast is not a reportable sex offense either. There are also reportable sex offenses that don't involve touching. Those are the touching ones. Not involving touching, indecent exposure, which is exposing a minor to another person's penis, anus, vagina, or female breast, or a sex act and excluding breastfeeding, furnishing harmful items to minors, like sending a depiction of nudity or sexual activity, including sexting, and it doesn't matter who's sending the text. If a minor is receiving a text, then it is a reportable offense. Secretly recording a minor without their consent in a private place where they have a reasonable expectation of privacy. This does happen in locker rooms and school bathrooms from time to time, so that is a reportable offense. Even just the recording without sharing it, if you share it, that's a second reportable offense, although, you know, one call, you report everything at once. And the use of minors in pornography or prostitution. So I said minor to minor. There's this exception for sexual conduct between teenagers. It is not a mandatory report if two teenagers are engaged in something that would otherwise be a mandatory report because it's sexual contact with a minor. If both parties are between 14 and 17 years old and it is consensual, no indication that it's anything other than consensual, then there's no mandatory report. There are also, just in case, you know, you go do your own research and look at the statutory rape definition, like this kind of thing, there's actually an exception for certain, like if an 18-year-old is having a sexual relationship with a 17-year-old, they're close enough in age, it's not criminal conduct, but it is a mandatory report. The mandatory report law doesn't bring in that defense. It just says you don't have to make a report if both people are between 14 and 17. Yes.
You first.
So does that mean, for example, when a teacher knows that a student who's just graduated is dating somebody who's a year younger, so they know that it's an 18-year-old and a 17-year-old, does that then rise to the level of a mandatory report based on this?
Not if they know that they're dating, and so
So it's
they have to know that they are engaged in a sexual relationship, which in our professional boundaries presentation, we say, you're not the counselor, the best friend, or the secret keeper of minors. And so when a minor, you know, a student comes to a teacher to say, if I tell you something, can you keep it a secret? The teacher should say, no, I can't, depending on what it is. Do you need to talk to a counselor or something like that? I mean, in our perfect world, teachers don't become aware, or board members become aware of that, but if you do, it is a mandatory report. I mean, and the thing is, the obligation of mandatory reporters is to make the report, and then you're done. The police, well, like I said, there is actually a defense to an 18-year-old and a 17-year-old having a sexual relationship. The police aren't going to pursue that because it's not even a crime,
But it's still a mandatory.
but it's still a mandatory report. Yeah. So,
Build off of that, because this is talking about like an 18-year-old who has consensual sex with a 17-year-old, emphasis on consensual, et cetera. But how much of this applies to what we saw in the previous pages, where it could be something like you witness over the clothes contact that would be considered inappropriate based on that description?
so I mean,
Between two people who you know are
still
dating.
consensual?
Consensual.
Yeah, okay, so if it's consensual contact, I mean, the girlfriend and the boyfriend, or the two people who are in a relationship together, are getting a little overly handsy at school, but they're both between 14 and 17, obviously they're gonna have a conversation about how inappropriate that is at school, but it's not a mandatory report, because this isn't just about sex, this is about any of that sexual contact. It is not a defense, it's not a defense to the sexting. So it would just be like touching the other person, basically.
And that you're saying is between 14 and 17, but
If
if
they're
one
both-
is an 18-year-old and one's a 17-year-old,
Then it's a
it is a mandatory
reportable.
report.
Yes. Yep.
And what if they're both below 14 years of age?
Reportable.
It's a mandatory report as well?
Yes.
Okay.
Either or both.
Whether it's
Yes.
consensual or not?
Correct.
Okay.
And if it's one or both are below the age of 14.
Correct. If anyone involved is under 14, if anyone involved is over 17, it's a mandatory report. If they're
Regardless of
both between
consent.
14 and 17, and it's any kind of touching, but it's consensual, it's not a mandatory report. Okay?
This is where our high school teachers really get
I'm
caught up.
sure, yeah.
Seriously.
Because how would you know the age of every?
Yes. They get
It's
caught
probably
up,
something we can find, our teachers can find out
Yeah.
if they have a concern, but
course.
yeah, that's a little crazy.
This is difficult for our
Yeah?
Yeah.
school teachers.
Okay, so sexual comments by one minor to another are not mandatory reports because they don't involve any of those reportable offenses or any kind of touching. But, you know, sexually explicit comments made by a young child might raise a concern about why they're using terms like that. And you're gonna see, I mean, you don't investigate to determine if you've got a duty to report, but we just say, if you hear a young child using terms that seem, or making comments that seem concerning for a child of their age, like be on the lookout, are there other signs that there's something here that I might need to make a report about? So what if the perpetrator of the abuse is a minor or doesn't know what they're doing? In other words, maybe they have a disability, a cognitive disability that's impairing their ability to understand the significance of what they're doing or the rightness or wrongness of it. It does not matter. If the person who is so we're taking out consent now, right? So if someone is touching another person in one of these inappropriate ways, it doesn't matter if the aggressor, the perpetrator, is a minor, is the sibling of the other person, is a student with a disability, an adult who lacks cognitive ability to understand what they're doing. None of those things matter. You still have to make a mandatory report. Because again, I mean, then you turn it over to the law enforcement, and then they determine what they're gonna do with it. And I mean, I am confident that there are many, many, perhaps the majority of mandatory reports where law enforcement are like, thank you for telling us we're done, basically, because, you know, this student hit this other student on the playground and he, you know, he's got a red mark on his arm or something, or, you know, the police aren't gonna follow up with that, you know, but you still need to make the report. Okay, so now we have a bunch of examples and they're all very teacher focused, so put yourself in that position. So you're Sam's
So if
first
you were,
grade.
so if you were volunteering, in a you know,
Yeah.
if you were
Right.
at a
And this is in
FFO
the
meeting, if
context
you were,
of-
yeah,
Performing our role as a governing
correct,
board member.
correct.
So
I mean,
I'm at
I-
the Safeway, that's a different.
So it
Well,
depends.
it
That's a good
depends,
question.
yeah.
I mean, and I did consider changing these all up, but I was like, no, these are good examples, and it's, you know, you see what everyone else is trained on, but it has to be in your role as a governing board member. So, you know, if you're in the Safeway and you see someone abusing their child and you don't know them and they're not, you know, nothing's being reported to you, you're just observing it, you don't have a duty to make a mandatory report. You can, it might be the right thing to do.
Right.
But you don't have an obligation to. But if someone comes up to you in the Safeway and says, aren't you on the governing board at Catalina Foothills? Because this is going on at this school, you now, and something gives you a reasonable belief, you have an obligation. So yeah, so it's not just in this room or when you're visiting a school. If it relates to your role and that's why you get this information, then you have the obligation under the law.
So in that, along those lines, secondhand information given to you is still enough of a reason to do a mandatory report.
Depending on it, the nature of it, but yes, a report from a third party could be sufficient to give you a reasonable belief.
Schools often get that. So parents will call the school to make a report to say, this is happening, and then we make the report. Because they may or may not be a mandatory reporter.
Right.
But they'll report it to us, and then we make that report.
Because that feels like a case where if you're at an FFO meeting or something like, and a parent approaches you about something that they heard from their kid about another kid, et cetera, you can go third, fourth hand, but it still is something, it's enough to say mandatory report.
So I'm gonna say, potentially, you have to have enough information to form a reasonable belief that child abuse or neglect may have occurred.
Yeah.
And so if it's like fifth-hand information that somebody who you don't know told someone who you don't know who told their kid, but no, you know, that maybe I think it's unlikely that rises to the level of you having a reasonable belief. But certainly, like, if one child comes up and says, I was over at my friend's house yesterday and I saw this happening, and this is what happened, you know, her brother hit her with a rock and, you know, she was crying and she was bleeding. I mean, that's really specific information. It's hearsay, you know, or whatever. It's not really hearsay, but it's secondhand information. but it's specific enough to form a reasonable belief that something bad happened. So it just depends on the nature of the information that comes to you.
Because I think part of the problem there is if, and we've run into this in other cases as well, a parent who will come up and say, I've heard this is happening.
Right.
You don't even know a name. You don't even know where to call and direct the police to say, you know, well, I heard from someone who heard from someone.
Yeah. I don't think a report to you, I've heard this is happening,
Yeah.
is enough to do anything with, except for potentially, depending on the nature of it, you know, have some kind of investigation happen. Maybe. I mean, even that depends. Like, it has to be specific enough for there to be something to investigate.
Right.
But then if an investigation does turn something up, then the person who learns it through the investigation is going to have the obligation to make the report.
Got it. So
So-
that would be a matter of just escalating.
Yeah.
Okay.
Okay, so you are Sam's first grade teacher, and he comes to school with a black eye and a large bruise on the side of his head. And when you ask him what happens, he hesitates and he mumbles something that you can't understand. And then you're like, what was that, Sam? And he says, oh, I fell off my bicycle. So to me, this is enough to make a mandatory report because the student's report does not seem plausible given the injuries that you're observing. And he doesn't seem like that's not the way a young person usually, he's a first grader, right? He's only 6 years old. That's like not a normal way for a sixth grader to explain what happened. It would be concerning to me that it was really something else that caused it. But on the other hand, if this exact same injury happens and I say what happened to him and he says, oh my gosh, I was riding my bike down this big hill and I hit a rock and I flew over and I hit my head and this is what happened and then my parents took me out for ice cream after I went to the emergency room, then obviously you're gonna believe him. I mean, I shouldn't say obviously, but I would believe him, right? So, I mean, that's kind of what we're looking at, like, those are the kind of facts that every person has to make their own judgment call about, like, given what I'm seeing here, do I form a reasonable belief that there could have been some non-accidental injury or neglect, or abuse, I should say, or does this look like an accident? And, you know, it's not always easy to tell. It's better to err on the side of caution. This could be a circumstance where you would seek out another person's opinion, perhaps, but if it's a super gray area, but again, better safe than sorry. So you're a school nurse, and John is a 9th grade history student who becomes angry, and he sits under his desk and refuses to move. And the teacher also becomes angry and pulls John from under the table by grasping his feet and dragging him across the carpet, causing him to get a rug burn. So a rug burn is a mark, and it is an injury. So John complains about what happened. Yes, that is a mandatory report. That is a non-accidental physical injury of a student. It's also obviously a report to the state board and cause for a disciplinary investigation into why the teacher acted in that way. Sarah's 6 years old and she's left at home unsupervised. Is that a mandatory report? You don't know enough because it's about having adequate supervision. A child is only being neglected if they don't have adequate supervision. So if she is a mature and responsible 6-year-old and her mother left her at home while she ran out to the grocery store, which is close by, and she's gone for half an hour, and Sarah knows to keep the door locked, not to use the stove, and to call her mom or dad if something bad happens, then that is not inadequate supervision under the law. But if mom or dad leaves Sarah home alone and she's found wandering the streets a couple of hours later, then Sarah was not mature enough to be left at home alone, and she was put in a position of being substantially at risk to be harmed, and that, I would say, would be a mandatory report. So yeah, this is kind of what was brought up earlier. Like, there's no minimum age in Arizona for leaving a child home alone, and it's not about individual persons, like personal standards, like, well, I would never leave anyone who is under 14 home alone. That's not the law. That's not the standard for a mandatory report. It's like, what's the basis for concluding that this is not safe for this child? You've got a student, Lisa, no relation, who frequently has body odor and or her clothes smell. She doesn't have a winter coat. She has attendance issues. She's not taking her medication. Is that a mandatory report? Hard to know. I mean, again, this is kind of aimed at teachers. They probably have more information than these 3 facts I've just told you, and so they've got in a position to kind of get a sense of what's going on. But if it appears, based on the facts that the reporter knows, that there is a substantial risk of harm to her health or welfare, then it's a mandatory report. But just the fact that different families have different standards is not, that's not the standard we're using to judge it. We're just really asking the question, is there a substantial risk of harm? So Sharon's 17. In class, she reaches down to the floor to pick up a book. Tom is also 17. He grabs her head and shoves it into his crotch. Is it a mandatory report? Yes. He caused her to touch his penis over his clothes. So she didn't do it on purpose. It's not like the mandatory report is about Tom because he's forced that sexual touching between them. And then we say out here, it's also probably sexual harassment, so it also needs to be reported to the Title IX coordinator, and so that whole process can happen.
Which is, I'm the Title IX coordinator.
Nick is a middle school boy. He kicks another boy in the groin area by accident during gym class while he pretends he knows karate. Is that a report? So I would say that is not a mandatory report because we're saying it was accidental. Now, it's not accidental in the sense that he didn't fall over, right? He intentionally was kicking, but he didn't mean to kick him. I would say this falls under that schoolyard scuffle situation because he's not trying to kick this boy in the groin. He's like, oh, look what I can do. And then, makes accidental conduct. It might hurt him. He might get a physical injury, not a mandatory report. Same thing if they're playing volleyball in class, and someone, swings back to get the ball and hits a girl in her breasts. Touching the breast is a mandatory report, not in a situation like this where it's totally accidental. But these kind of accidental, exceptions, especially for the touching, what we call the 4 areas, it's not a mandatory report because it's an interaction with a minor that an objective, reasonable person would recognize as normal and reasonable under the circumstances, right? It's just an accident. The first one's an accident. The second one is just in the course of playing the sport, accidental contact. Because remember, it's only the physical injuries that are non-accidental. Touching, it doesn't matter if it's accidental or non-accidental, but in a general sense, like that's not part of the definition of it, but this was not a sexual touching. This was just accidental, incidental contact. So it's not a reportable offense, but we say, be cautious about that and don't overuse that exception. Like if it looked like there was an ulterior motive for swinging their arm in that particular way, so it's like, oh, that was an accident, but it doesn't look like it was an accident, then it's a mandatory report. Aaron takes pictures of his girlfriend's breasts on his cell phone. He sends the picture to his friends. He secretly takes pictures of other players showering while naked after practice and sends them to his friends. Aaron's girlfriend takes a picture of her own breasts and sends them to Aaron. All of these are mandatory reports. It doesn't matter that, especially, the first 2 seem quite obvious, but even the last one where the person whose body it is sends the image, if she's or he is sending it to a minor, even if it's their boyfriend or girlfriend, that's a mandatory report. Susie's in 3rd grade. She tells you that her brother touches her pee-pee. You report the matter to the school nurse, who reports the matter to the principal. How many mandatory reporters are there? 3. You, the nurse, and the principal. How many reports need to be made? 1. So who should make the report? I would say the person who is you in this, because they got the report most directly, but it really doesn't matter. Like there's no rule that it has to be a particular person. So if that person is a teacher and the school nurse is like, and I need to get right back to class, the school nurse could say, I'll make the report because I'm free right now, but then send that follow-up email that lets everybody know that it happened. Lindsay's a 4th grader. Her mother says that Lindsay reported to her over the weekend that she was sexually abused by her cousin. And Lindsay's mother tells you that there's no need to report the matter to the police because she already contacted the police. So this is not a teacher-specific one. This could be a board member. So assuming she's telling you because you're a board member, when she tells you this is what happened, Lindsay says she was sexually abused, I've already reported it to the police, do you have an obligation to make a mandatory report? Yes, you do. Because hopefully she did, but you can't rely on that. You need to make sure that you make the report. Okay, so reasonable belief. We've kind of talked about this a little bit, but you don't need visual evidence about the offense And information that could lead you to form a reasonable belief could come from a variety of different sources. This is kind of like what you were just asking about. It could come from another student, it could come from a parent, it could come from a family member. One sentence from any one of those sources might be enough to form a reasonable belief. Obviously, something that you observe also, if you observe the actual act, then you're gonna have a reasonable belief for sure. If you observe some injury and then you know, ask what happened, and the explanation might be enough to give you a reasonable belief. But it is not your obligation to determine whether or not the information that you get is true, and it is not your obligation to investigate. And especially when we're talking about children, I mean, asking too many questions can really impair the you know, law enforcement's ability to get good information from the student. And so, you know, we say, like, if somebody comes, well, obviously if a report comes to you like, this happened to this student, and it's enough to make a report, you don't need to ask any questions, right? You got the information, like Lindsay's mom saying her cousin abused her last weekend. You have all the information that you need to make a report. But if it's one of the situations where like you're seeing the injury, the questions are, what happened? Who did it? When did it happen? Where were you when it happened? Now you know everything you need to know, because you can call the police and say, I want to report a non-accidental injury about this child who I observed bruising, and they told me that this happened yesterday at home when their parent struck them. Okay, that's everything you need to know. You don't ask any more questions like, does this happen very often, or did anybody observe it? It's not your job to investigate. You just find out the basic information, stop, and make the report. Don't conduct interviews, don't speak with the alleged perpetrator, and don't promise to keep the information confidential. And then this is just I've said this once already, and I've usually said it at least twice by now when I'm giving this presentation to teachers, but a principal or a site administrator should never insist that they have an opportunity to screen the information before the report is made. They might help you to make a report, but you can't wait. The teacher can't wait for the principal to be present if it will delay that for more than a couple of minutes. So again, like if a teacher gets some information and they get someone to watch their classroom and then they're gonna go make a phone call, it's fine to walk to the principal's office and say, I need to make a mandatory report, can you sit in with me? But not if the principal is off campus for the next few hours, you don't wait till they come back, because that's not immediate. But then, as soon as possible, they should be informed what happened, or in your case, the superintendent. So the law, 133620, that's the mandatory reporter law. It provides that a person who makes a mandatory report is immune from any civil or criminal liability unless they acted with malice, you know, made the report solely for the purpose of like getting at somebody, even though it was not true. So there's no, you can't be, like I said, held liable for doing it. It says this is a safe harbor. But there is also no guarantee of confidentiality for a mandatory reporter. It's possible that law enforcement or DCS will tell the parent who made the report, and there's nothing that you can do about that. So the only reason why we bring that up is like, if there's a real concern about a particular person, I mean, we tell teachers, like, if you're making a report and you're concerned about that parent's volatility or something, and you're worried that they're gonna know that you made the report, like, talk to the principal or the site administrator about how you can make sure that you're staying safe. But there's nothing that we can do to guarantee that that information wouldn't come out. Also, so if a mandatory report has been made, then the district, the schools always inform the parent, like, that if it wasn't about the parent, right? So when one child hurts another child, or sexually assaults another child, or any of those other things, and there's a mandatory report, of course that information is being provided to the parent of both parties, that, you know, but including the perpetrator, like, we had to make this mandatory report about your child. If the report is about the parent, though, then that information is not provided to the parent, because again, just like with asking kids too many questions, it would interfere with the ability, potentially, you know, of DCS to do what they need to do, or of the police to do what they need to do. So we tell all teachers, and I would tell all of you too, like, you don't need to answer any questions like that. To the limited extent that questions need to be answered, that would go through the superintendent. as well. So we've been asked, like, well, what about if kids are hurting themselves, like cutting or threatening to commit suicide? Those aren't mandatory reports. They should be referred to the principal or the school counselor. But unless there's some evidence to conclude that they're doing it because they're being injured by someone else, injuring oneself is not a mandatory report. And this is a link, in case you feel like that was interesting, I'd like to see it all over again. This is a link to training that was done by the state of Arizona, and it's out there. It's much more general, but I would put this in there because I think it's good if someone feels like they or their staff needs to like go over it one more time. This is just a free thing. You can click on that link and watch a training on this exact same topic. I have watched it, and we do cover everything that's in that training that's relevant to schools in our training. But this one's more general because it's for anyone who is a mandatory reporter. So, do you have any other questions? Yes.
And I think part of what I'm trying to figure out is that in the role of a governing board member piece, specifically because we are a pretty small school community. If I see a parent in a Safeway who is hitting a child, and I know that that parent is a CFSD parent and that child is a CFSD student, does that change anything about, it's not something that, you know what I mean?
Yep, I do. And I think that's a gray area, honestly, because I don't think you're getting that information in your role as a governing board member. You're getting it in your role as a grocery shopper. But I would say, why not make a report? Because if you're seeing that happen and a child is at danger, then the best thing to do is to make a report and let that something, the right thing take place thereafter. But if you're just out in the community observing something you're not at a school event or anything like that, then it doesn't fall within your obligation as a governing board member.
And if it's a disciplinary smack, that it's no way to tell in the moment if it's going to leave a physical injury.
I agree with you. I mean, I think if you saw a parent, giving what looked like a disciplinary smack to their child, you would not have a reasonable belief that they were being subjected to child abuse.
My other question is the trickiness of the 4 areas. So let's say hypothetically a non-accidental groin kick delivered in self-defense or feeling threatened. So I know there's beyond all of this is just the normal violence, bullying, whatever those things are. But as soon as there is contact made to one of the 4 areas, does it immediately fall into this category?
I would say yes.
Okay.
Because again, you're making the report. I mean, the law enforcement can say that was self-defense.
Okay.
We're done. But you still have to make the report.
Okay. Thank you.
Sure. Anyone else?
Do we have access to this PowerPoint?
Yes.
Okay.
Can we go back to the neglect section?
Yes. Do you want me to actually go to the
Would it
slide? Or
help
do
if I put it into a print form and put it in the weekend review so that you just have?
That'd be great. Yeah, thank you.
You don't have to go back to
Oh. Here's a voice from above.
For the weekend review, for the weekend review, putting it in the weekend review.
It's this voice from above. God has spoken.
It'll be in the PowerPoint.
It's in the PowerPoint, yeah.
Neglect is a topic, sorry, you don't have to go back to the
Yeah, okay, understood.
So that's my train of thought there. Okay, so you touched on an example of a parent showing up intoxicated in a car or something like that. I used a specific example. Can you just dive into that a little bit more in terms of alcoholism, drug abuse in the home situation? No visible signs of neglect to the child. They're still coming to school. They're still dressed appropriately. This, that, and the other. But the knowledge that there is severe alcoholism or drug abuse in the home environment. But I have parents' thoughts on that.
Yeah, I mean, I think it's a very gray area. And I mean, just, by way of disclosure, I mean, none of my examples are in the law or, we it's something that me and some other attorneys in my office kind of put together as things that, how we would interpret it. And so I think it is definitely a gray area, and it would just depend on what facts you know. I mean, if you know that a high school student's parent is an alcoholic, but there's no physical abuse in the home, and so they might be exposed to overconsumption of alcohol, but they're not at substantial risk of injury, I don't think there's anything to report. If you know that a parent or an older sibling leaves, drugs out on their dresser, and there's a 7 or an 8-year-old in the house, then I think that 7 or 8-year-old is at substantial risk of injury because accidentally or on purpose, they could take those drugs and have a very serious outcome. So it's just gonna really depend a lot on a little bit more about what you know.
It's a more contextual.
Yes.
Okay, fair enough.
Okay.
Great presentation.
Well, thanks for your attention.
Thank you.
Thank you.
Thank you.
We have a whole,
Do. We will.
yeah, the main meeting will not begin until 6:30, so yeah, you guys have a half an hour to, I don't know, eat your dinner.
Yes, we'll take a 30-minute
Right, have a good
recess.
night.
Thank
Thank
Thanks,
you.
Lisa.